this aspect of the matter has not been properly considered by the learned first appellate court while refusing to condone the delay in filing the first appeal. आपके सूट का वैल्यूएशन कितना था? सूट का वैल्यूएशन कितना था?
$3 lakhs.
3 lakhs तो हाई कोर्ट में फाइल होता है आपका अपील यू आर अंडर कंफ्यूजन 3 lakhs में तो हर हाल में वहीं पे फाइल होता है पहले भी वही फाइल होता है उसके बाद भी वही फाइल होता है 25 लाख कितना 10 लाख से ऊपर हुआ था
हाई लाख शायद it was
2.5 lakhs
कुछ
पहले कितना था 1 लाख 1 लाख से 25 लाख
नहीं पहले जो था वो 2.5 lakhs अपीलेट कोर्ट का 25 लाख
2.5 से 25
लेकिन जो भी जूनियर डिवीजन का जो भी अपील होता था वो डिस्ट्रिक्ट जज के यहाँ होता था।
ठीक The learned counsel for the appellant has submitted that the sale deed executed in favor of the appellant has been cancelled by the learned trial court, and the learned first appellate court has not entered into the merits of the case on the ground that the suit was barred by limitation, without considering the aforesaid confusion which arose with respect to the jurisdiction of the High Court / First Appellate. आपको डॉक्यूमेंट फाइल किए थे अपने मेडिकल को फाइल किए थे लोअर कोर्ट में कि नहीं किए या नहीं पता
नहीं पता है
The learned counsel for the appellant has submitted that as a counsel he is not aware as to which documents were filed before the learned trial court or if at all it was filed with regard to substantiate the claim of the appellant regarding his medical condition. Right? Appellant number 1 regarding his medical condition. After hearing the learned counsel for the appellant, this appeal is admitted for final hearing on following substantial question of law. Whether the learned first appellate court was justified in dismissing the appeal on ground of limitation without taking into consideration the petition for condonation of delay in totality. इतना ही खाली बना दो, ठीक है? Got it? ऊपर लिखेगा उतना वो नहीं, वो अभी नहीं बनेगा, अभी तो खाली लिमिटेशन पर ही बनेगा. लिमिटेशन अगर आपका कंट्रोल हो जाएगा तो मैटर रिमांड हो जाएगा, है ना?
It was 2,50,000 which was ultimately increased to 25.
अगर भाई लिमिटेशन अगर कंट्रोल हो जाएगा तो रिमांड हो जाएगा ना मैटर. He has submitted that the pecuniary jurisdiction was enhanced from 2,50,000 to 25 lakhs, and the suit was valued at 3 lakhs. Correct? चलिए, issue notice to the respondents for which requisite under कहाँ पे एड्रेस दिए हैं? Requisite under ordinary process as well as speed post be filed within a period of 15 days from today. Office to track speed post delivery. The counsel for the appellant is directed to file a fresh typed copy of the party position of the memo of appeal. ठीक है, उसका फ्रेश टाइप कॉपी फाइल करिए. इतना कटिंग है नहीं पॉसिबल है, हम लोग ऑर्डर भी नहीं टाइप कर पाएंगे. आप इसको देख लीजिए, इसको लेट खाली फर्स्ट एपेलेट कोर्ट का रिकॉर्ड से लेट द रिकॉर्ड्स बी कॉल्ड फॉर फ्रॉम द कंसर्न कोर्ट. ये नोटिफिकेशन निकाल के रख लीजिए. आप नोटिफिकेशन का एक प्रिंट दे देंगे, हम डाल देंगे उसमें. He has referred to notification number Act by Act 9 of 2019. Which is dated 11/6/2019. ठीक है? As per date. August 18th. ये सब जुगाड़ कर दीजिए. अब उस दिन मेरा बेंच रहेगा, किसी और का बेंच रहेगा. लॉ तो लॉ की तरह डिसाइड होता है ना, वो सारे जजमेंट्स भी जुगाड़ कर दीजिए. सेकंड अपील वुड बी मेंटेनेबल. सीनियर लोग के
ये क्वेश्चन उठेगा ही,
ये जरूर उठेगा फिर से. अभी तो सीनियर लोग बोले तो हम मतलब सिंस दे हैव अ स्ट्रेचर आई नो कि वो लोग जो बोल रहे होंगे सही बोल रहे होंगे. ऑफिस का भी कोई ऑब्जेक्शन नहीं है सकता. ठीक है, चलिए. पासओवर भी है. किसका पासओवर है?
पासओवर आइटम 23.
आप कौन है?
हम एपेलेंट.
हम लोग का एक फिक्स केस चल रहा है, उसको बीच में नहीं. पासओवर जब होगा ठीक है.
किस केस आइटम 2 सेकंड 309 of 2016.
concluded,
Yes.
but only 2-3 judgments are in place. That is.
Yes.
probably my learned friend has given this Prabha means judgment.
हाँ.
So I
That is
don't.
the rest of the judgments awaited. आप लोग को जो जजमेंट प्लेस करना है, एक तो अपनी तरफ से एक लिस्ट हमको एग्जॉस्टिव दीजिए. लास्ट टाइम नहीं था, शायद आपने दिया नहीं था लिस्ट. बताइए आप कौन कौन से जजमेंट.
ये है Prabha Meech. This was second appeal numbers 127 of 2014.
सेकेंड अपील नंबर
127 of 2014.
127 of
2014.
24. Judgment dated
This is dated 24 to 2022.
और आप क्या डिनाई कर रहे हैं?
हाँ.
This is one.
2003 SCC online Jharkhand 432.
Party naam?
This is Dhani Maji and another. Dhani Maji and another versus Ranga Maji and other. This is division and same Santhala question is there. If Prabha means is there, I'm not supplying this.
127.
The probability is there.
Have some.
तो ये बता.
ना एक चीज और, वो जो
First-
उसमें सब्सटेंशियल क्वेश्चन ऑफ लॉ पहले तो लिमिटेशन पर ही ना थे.
और 41 और 31 जो कि इन्होंने कहा कि हम डिप्रेस
नहीं, इसका नहीं बोल रहे हैं.
नहीं
वो वाला केस है, तो लिमिटेशन वाला. अभी मेरा माइंड अभी
इससे
स्टार्ट
पहले
अच्छा
हुआ.
अच्छा
उसमें तो लिमिटेशन पर ही था
हाँ,
पहले
हाँ.
सब्सटेंशियल क्वेश्चन ऑफ लॉ. उसके बाद ही होगा जो होना.
नहीं, नहीं,
That difficulty is there unless that limitation is condoned, then only other things can be.
मैटर भी
हाँ. If it is decided in their favor, then the matter has to be remanded.
Yes.
Sorry, थोड़ा दिमाग स्टक.
नहीं वो जगह है थोड़ा.
कंफ्यूजन है उसमें.
हाँ हाँ. And
और भी पहले भी
fortunately
हमने
my
देखा.
learned friend has
क्योंकि
pointed.
पहले भी हमारे एक आध केस में हमने भी देखा है. कमल कुमार के केस में भी ऑनरेबल जस्टिस एन तिवारी का जजमेंट है. उसमें कोई प्रोपोजिशन ऑफ लॉ पर हमको लगता है डिस्प्यूट.
But your lordship, unless delay is condoned,
तब तक कुछ हो ही नहीं
there is no question of.
अगर consequence of delay, if the appeal itself is not dismissed, if suppose delay is not condoned,
नहीं, मेरा ये कहना है मिस्टर शर्मा, in a case of second appeal of this nature, where the first appellate court has dismissed the appeal on limitation,
why?
तो जब तक लिमिटेशन का हर्डल नहीं पार होगा तब तक मेरिट में घुसने का तो स्कोप नहीं है ना. तो सब्सटेंशियल क्वेश्चन ऑफ लॉ तो सिर्फ इतना ही बनेगा एट दिस स्टेज.
बस.
उसका
और
अलावा
ऐसे ऐसे भी appellate court का कोई जजमेंट है नहीं
है
except dismissal on the ground
Yes.
of delay.
That's-
इसीलिए उसी से होगा.
थोड़ा सा सेलिएट सेट असाइड कर दिया है.
एक
थोड़ा
बार-
सा
एक
लगता
बार
है.
लेटनी देवी वाला जजमेंट देखा जाएगा. तो 2001 सुप्रीम कोर्ट का
जरूर देखिए.
उसमें सुप्रीम कोर्ट ने कहा था कि नहीं, देयर इज नो एडजुडिकेशन ऑफ मेरिट, सो नो डिग्री. लेकिन 2005 में उसको उन्होंने ऑनरेबल एपेलेट कोर्ट में कहा कि देखो.
आई सी. चलिए ये बताइए. Now,
Your
now
lordship
let's
has
back and focus to the
Prabha
case.
Meech.
हाँ, Prabha Meech. थोड़ा सा facts please.
Facts are.
A different substantial question of law. Facts थोड़ा please करिए.
First para 8 your lordship may see. The main plea in this case, the suit had been filed by Prabha Meech, claiming a right on the ancestral court,
Yes.
and they were overrounds.
पूरा.
So in that also, there is a claim. It has always been in confusion as to what would be the effect of Urao customary.
And हमारे केस में कौन है?
हमारे में संथाल.
The observation in that gangster settlement is common with respect
Yes,
to all.
that has also been quoted by the Honorable.
Let's
Your Lordship may see the main defense that was taken by the defendant in that case.
yes.
The main plea of contesting defendant number 1, 2, 3 is that both the parties are members of scheduled tribes and are governed by their customary law of succession, in which the females are excluded from inheritance and the plaintiff has no right, title, interest and possession of the suit. Then your Lordship may skip all others. Then para 13, the question of law, substantial question of law has been provided. Second question we are concerned, whether the alleged custom amongst the
Please go by
tribals,
ये para number 10. Roman 3 was the issue framed by the trial court. Para 10.
para numbers
10.
10, yes.
ठीक है रोमन 3
Yeah.
ट्रायल कोर्ट का फाइंडिंग
हाँ, ठीक है. Whether the Urao customary law daughters are heirs and entitled for succession. And in that case, where that finding is there of the
सीधा
trial
है
court, I
यही है
don't have.
ये यही है यही
हाँ.
पे रिपोर्टेड है. It has been held that as per the customary law of inheritance as applicable to Urao tribe, the females are debarred from inheritance.
अच्छा, ठीक ठीक.
ठीक है. अब appellate court ने क्या किया?
Appellate court
They
concurred
simply
with the
dismissed
finding on absolutely same concurrence.
Substantial question.
Then the substantial question of law, the second one we are concerned with. B. Whether the alleged custom amongst tribals debarring females from their right of inheritance over the lands left by the ancestors satisfied the test of a binding custom as laid down in the Lakshmi Bai death through so and so, reported in 2013, volume 4, SCC, page 97.
That's
And then my argument has been noted in para 15, and the second last para of the same page your Lordship has. This is concerned with the second question. The second limb of argument is that the customary law of inheritance applicable to member of scheduled tribe of Urao caste, under which it has been pleaded on behalf of the defendant that the females are debarred from inheriting the property of their ancestor. It is argued that all customs do not have a binding force unless and until by its prolonged and uniform use from ancient time, it has acquired by continuous and compulsory practice binding force. No custom is valid if it is illegal, immoral, unreasonable or opposed to public policy. Any customary law which is selectively followed cannot be said to have acquired the force of law. It is submitted that the custom of debarring a female from inheritance is of a remote antiquity, but there is no evidence of continuous and consistent practice so as to draw an inference that it has acquired binding force. The judicial precedence is not uniform on this point. There is large volume of judgments and orders passed by the civil court as well as revenue courts and also by the High Court where such customary law of inheritance debarring females from inheritance has not been recognized and accepted. These are the cases where the females have been excluded from inheritance. There are cases where the females have been excluded from inheritance on being barred by customary law. At the same time, there are cases where the females have been given hereditary rights in the teeth of objection that the females had no hereditary right. The divergent judicial pronouncement are evidence of inconsistency on the customary law of inheritance being followed by the tribals. Unless any custom has been consistently and uniformly followed, they cannot be held to have a binding force. Now in Joseph Munda versus Musammat Khudi, here I'll pause here. This is one of the another case where this was the honorable court. This honorable court itself, it passed an order against the customary law which was pleaded by the party. It has been referred to demonstrate that the High Court refused to deny right to inheritance to a female on the ground that it was barred under customary law. In this case, it is evident that not only the revenue court but also the High Court recognized the right of female inheritance of a female of a member of scheduled tribe. It is apparent from this judgment that despite being the daughter, the name of Musammat Karuna, her name was entered in revenue record of right, and that too after rejecting the objection of the ancestors of the plaintiff. Secondly, despite being a female heir, she was recognized as heir, and subsequently it was also accepted by the ancestors of the plaintiff in the year 1931. the court refused to apply the said custom, debarring female from inheriting. Reliance has been placed on Lakshmi Bai versus, again, I am not repeating this here. Again, that custom
That's
has
the
been.
same.
Then you look at para 17. Here there are two portions. One is S.C. Roy's Uraus of Chotanagpur, and another Ganja's report has been mentioned. It is argued the main source of customary law among so and so of the state of Jharkhand from which it is derived that the females are completely excluded from hereditary line is the book Uraus of Chotanagpur by Sri S.C. Roy, and with respect to Santhal tribes, the Ganja's report. Both these sources are about 100 years old and do not indicate even in those times, custom of debarring female from inheritance was not uniform, and with change in socio-economic condition, it was losing traction. The Ganja's report notes the rules against female succession amongst Santhals, whether Christians or non-Christians, are changing owing to the force of public opinion, and the rules which have been previously accepted cannot be treated as hard and fast and binding for all time to come. The change which is occurring in the nature of ameliorating the condition of a woman and giving them a more assured footing in the family. During the course of revision of settlement operation, the daughters of a deceased Santhal have sometimes been recorded as heirs, not only without opposition from the agnates, but at their request. In other cases, it appears from the title suit decisions that the arbitrators in Santhal cases have found in favor of the daughters. This is particularly so in the case of girls who suffer from any physical defect. In dealing with the cases of this nature, the custom adopted in a particular locality must be carefully considered. This report has come in the year 1935, and the winds of change in the law of inheritance has been noted by the author of the report. Similarly, in page 223 of the book by S.C. Roy, Sri S.C. Roy, it has been noted changes in the economic condition of the Uraon's life have introduced important modifications in the two fundamental rules of Uraon customary law of inheritance. Then you know, para 18, this Madhu Kishwar was argued, relied upon last 5 to 6 lines, and then based on Madhu Kishwar, this was opposed. Then para 35. Because the other question that was being dealt with earlier. In view of the finding of the first substantial question of law in favor of the appellant, a finding on the second substantial question of law survives because the defendants have questioned the right of the plaintiff on the very ground that the females are not entitled to inheritance. The question raised is of fundamental and seminal significance, and it is to be tested in the instant case whether customary law of succession disinheriting female had acquired a binding force of general customary law. An irregular and inconsistent practice of a custom cannot accord it a binding force of general customary law. There is a difference between general and special custom.
The same thing quoted.
Same.
Then Salmon.
Then your Lordship, para 37, Salmon and all those have been quoted. Your Lordship may then para 38, 39 onwards. 38 again, the Honorable Supreme Court in the Lakshmi Bai precisely alluded to this jurisprudential requirement while stating that a custom must be proved to be ancient, certain and reasonable. The evidence adduced on behalf of the party concerned must prove the alleged custom to be uniformly and consistently being followed. The question that besieged consideration is whether the tribal customary law of inheritance, excluding inheritance from inheritance, it would be actually excluding females from inheritance, has acquired the binding force of general law as per the test and requirement laid down above, whether they have been uniformly recognized and applied by the courts. A brief reference to some of the cases shall demonstrate that such a custom
There
has
is
not been.
inconsistency in the judicial pronouncements.
Yes, there is no consistency there also. then in that case also, Your Lordship, page 18, last paragraph, relying on this is a Madhya Pradesh High Court judgment. This I may be allowed to read.
Page
The
18.
question whether a
Yes.
Urao customary law of the females were barred from inheritance in the light of commentary by Sri S.C. Roy under the title Urao customary came off for consideration in so and so. It is true that where it was, this is the quoted part. It is true that the provisions of Hindu Succession Act 1956 do not apply to the members of scheduled tribe as per section 2 of this act. It is also true that the parties to the suit belong to the Urao tribe, which is a scheduled tribe. The real question is whether, according to the caste custom, the plaintiff is so entitled to inherit the share of her father in the lands in dispute. She has no brother. It was a peculiar feature of old Hindu law, based on the interpretation of Vedas and Smritis, that a daughter is not entitled to inherit the property of her father if he had left behind a son. In the absence of a son, the daughter was entitled to inherit, and she used to get limited estate, and on her death he used to pass on to the reversioners of her father. That rule of Hindu law has been abrogated by section 14 of the Hindu Succession Act 1956, which confers full heritable capacity on a female heir. In the present case, there is no definite evidence that the Urao's daughter is excluded from inheriting the property of her father in all these circumstances. The evidence adduced by the defendants has been perused by this court. The witnesses have stated that the daughters have no right of inheritance in their community, but they have not cited a single instance in which the daughter has been excluded from inheriting the property of her father, even in the absence of a male issue. Therefore, the First Appellate Court has rightly held that the plaintiff is entitled to inherit the share of her father in the lands in dispute. The burden was on the defendant to establish that there is a custom which excludes a daughter from inheritance, even in the absence of her brother, and even if her husband is brought as a guardian. A daughter is also entitled to be treated with equality. There should be no disparity in the right of a man and woman in the matter of succession and inheritance. That is now recognized in all the systems. The customary law of scheduled tribe has been preserved under section 2 of the Hindu Succession Act, but in a given case it is for the person setting up a plea of exclusion of a daughter from inheritance to prove and establish that there is such caste custom. A custom is a rule which has by long uses obtained the force of law. It must be ancient, certain and reasonable. It should be established by clear and ambiguous so and so. It is also by means of such so and so. It can be assured of its existence and the fact that it possesses the conditions of antiquity and certainty on which alone the legal title to recognition depends. It is incumbent on the party setting up a custom of allege and proves that the custom on which he relies. Thereafter, a brief review of the case laws discussed above shows that the courts have adopted divergent approach while dealing on the matters related to the customary law of inheritance in the case of tribals. Each case has been considered on its own merit, and there is no uniform or universal application, recognition. To, yes.
You see, there is no consistency in
Yes,
judgments.
yes.
There is inconsistency has already been recorded in the
Yes.
report. Madhu Kishore was a judgment which was dealing with the virus of such custom.
Yes, exactly.
So
Exactly.
that was not a case arising out of a first appeal or a second appeal or
And Your Lordship, there was challenge to provisions of CNT Act,
that's right.
where section 7, 8 and all those sections were challenged on the ground that
So that judgment, according to you, may not apply because you are not challenging any provision. You are saying that the custom has not been established.
even in that Madhu Kishore, I may be allowed to point out only two things.
They are given Madhukeshwar.
Yes. Madhukeshwar, your Lordship may see, starting line as your Lordship pointed out, that in the two petitions under Article 232 of the Constitution, challenge is made to certain provisions of Sultanate Tenancy Act so and so, which goes on to provide in favor of the male succession to property in the male line on the premise that provisions are discriminatory and unfair against women and therefore ultra vires. So these were the challenges.
That was the challenge. The
Yes,
statutory provision was challenged. Is there any statutory provision excluding inheritance by female?
No. It only
Then what is section 7 and 8?
7 and 8 only it says your Lordship may para 5 last 3 lines first your Lordship may allow me to place that Madhukeshwar first and then
Madhukeshwar का judgment आप
I thought that
नहीं इस bunch
probably my learned friend
वो तो पिछला दिन का अपना list of judgment कहाँ दिए
I
हम लोग को promise करके नहीं दिए तो हम लोग
multiple
बोले कि
copies
जो है
होगा
वो-
इसी के लिए हम नहीं दिए नहीं तो हम नहीं दे
नहीं तो आप हमको जजमेंट को आप ऐसा सीक्रेटली क्यों रखे हुए हैं उसको दे दीजिए आपको
वो हम
There
multiple
is no
copies होगा
secrecy in
unnecessary
judgment.
इसी के लिए
वो लीजिए जजमेंट का सच
पेज नंबर
Madhu yes 7 and 8 of CET.
Yes, that was the challenge. And then para 5, last 5 lines.
इसमें numbering नहीं किया है। बताइए।
Para 5 starts with, in the face of these divisions and visible barricades. And last 5 lines. We agree, therefore, with Brother Justice K. Ramaswamy, as summed up by him in para ending page so and so of his judgment on the. It is that under the circumstances, it is not desirable to declare the customs of tribal inhabitants as offending Article so and so of the Constitution, and each case must be examined when full facts are placed before it. So those facts were never there, no custom was there before. Therefore, the Honorable Court said that it is not desirable to.
So your case would be, irrespective of whether the parties are governed are Hindus or Christians, because plaintiffs said that they were Christians, and defendants said that there was a conversion later on.
So both the parties have said that
Here
the
there is no
government-
conversion.
that
There
is-
is-
Here is no. Here there is no conversion. Here only they are Christians. We have said
Okay.
subsequent
Parties are Christians,
Christian.
but instead
Governed by
of
tribal.
just a moment, in case this court holds that customary law of inheritance may not be applicable, then under such circumstances, since she was the sole surviving here, it makes no difference that
Absolutely.
under which secular law or which
Absolutely.
religion she is belonging to.
Absolutely.
There is no question of deciding any further inheritance over here.
It is not required. But
That is not required.
their whole case is that there is a custom which debars
That's
female
it.
from heredity, and the moment they fail to establish that custom, everything the plain Jogaman she would succeed.
That's right.
There is no dispute so far as the
हाँ,
applicability
हाँ,
of
सर।
tribal.
What else?
सर हम
What else?
Para 9. After quoting section 4 to 7, 76 of CNTR, then para 9, the conclusion is a bare outline of these provisions goes to show that these have been enacted to identify the classes of tenants. These provisions have no connection with the ownership of the land. First, this was the, and then last 3 lines, all these tenants as classified do not own the tenanted land but hold under others. The tenancy rights are identified and regulated through these provisions. The personal laws of the tenants nowhere figure in the setup. So, therefore, the custom was not there in question. It could not have been. Therefore, the Honorable Court says that personal laws of the tenants nowhere figure in this setup. So, therefore, Madhu Kishore cannot be taken as laying down that no, females do not have a right to inherit under the tribal custom. It has not put a stamp on the so-called custom. And therefore, the Honorable Court said that each and every case has to be decided when the facts are there before you.
That's all.
The second one, full division bench of our own High Court, which I had referred, 2003 volume SCC online, 2003 SCC online, Jharkhand, 432. Only 2 pages here. 3 pages.
432.
432. This is Dhani Maji. Your Lordship, because it is very only 3 pages, only relevant para 3 may be allowed to be. Or para 1 onwards, Your Lordship, because the plaintiff or appellant, they filed a suit for declaration of their title over B and so for recovery of possession on so and so. The suit was registered by the defendant, the suit was dismissed by the trial court, and that the dismissal was confirmed in appeal by learned single judge of this High Court. Hence, this appeal under clause 10 of the letters patent.
Primarily a second appeal.
Yes, practically. The plaintiffs are the sons of Dhuma Maji. Dhuma Maji had a brother, Batol Maji, and alias Bajol Maji, who died before 1961, leaving behind his widow and daughter Kandri Majiai. Of course, there is a controversy whether he died in the year 1961 or in the year 1926, whether whatever it be, he left a widow and a daughter, Kandri Majiai. The defendants in the suit are the husband of Kandri Majiai and her 4 sons and daughter. This is very important. So, exactly in our case also, this is. According to the plaintiff, the suit properties were ancestral, and on the death of Batol Maji, his married daughter would not inherit, and at best his widow had only a limited interest, and the plaintiffs were entitled to inherit the property. According to para 6 and 7 of the plaint, a custom was prevalent that on the death of a santhal, his married daughter or widow were not entitled to inherit the property absolutely, and the married daughter had no right at all. This was controverted in written statement. Then whatever is there, Your Lordship may kindly skip. Next page, first line. Thus the claim of the plaintiff that they were entitled to inherit exclusively on the basis of custom was disputed. In support of their plea of custom, the plaintiffs examined 2 witnesses, one a young man of 30 years of age and the other an old man of 70 years of age belonging to neighboring village. The trial court found that the 30-year-old man was not competent to give any evidence on the custom among the santhals of that village. The trial court also found that the evidence of 70 years old witness from the neighboring village was general and not specific, and he could not say anything about the custom followed by the santhals in the village in question. As against this, the defendants also examined some witnesses. The trial court found that those witnesses had given specific evidence to the effect that on the death of a santhal, the properties were inherited by a married daughter. They spoke of specific instances of such occurrence in the village in their evidence. The trial court also noticed that in in the 1926 Abdul survey, the Schedule B properties were recorded in the name of widow of Batul Maji, and that the tank alone was recorded in the joint names of Batul Maji and Ruma Maji, the father of the plaintiff. From such evidence, the trial court came to the conclusion that the defendants have shown that there was no custom by which the married daughter was excluded. Whatever it may be, the trial court held that the plaintiff had not established any custom or exclusion of a married daughter as pleaded by them. Taking a view that the parties had become sufficiently Hinduized and so to apply, then it dismissed the suit. The learned single judge in the appeal by the plaintiff agreed with the trial court in its finding on the appreciation of the evidence that the plaintiffs have not established the custom set up by them. The learned single judge also proceeded to confirm the finding that the parties had. So there were two findings. Then, para 4, the learned counsel for the appellant drew our attention to the decision of Supreme Court in Madhu Kishwar versus so and so, wherein their lordships have held that the Santals are governed by customary law and that the custom varies from people to people and region to region. Their lordships have also held that neither Hindu Succession Act nor the Shariat law governed the tribals and they were governed by customary law. It is therefore clear that whatever relevant in this case is whether the plaintiffs on whom the burden lay have established a custom among the tribals in question or exclusion of a married daughter from inheritance. As we have noticed that there was controversy whether the Schedule B was ancestral and belonged to so and so, so and so. We find on appreciation of the evidence in this case in the light of reasons given by the trial court and the learned single judge, that the learned single judge was fully justified in affirming the finding of the trial court that the plaintiffs have failed to prove the custom of a married daughter being excluded from inheritance. Once the plaintiff failed to prove the custom set up by them, obviously they are to be non-suited. We have also noticed that the plain Schedule B was recorded in the exclusive name of Batul Maji, the F Schedule so and so, the tank alone, in view of the convenience of possession of the properties jointly, was recorded in joint names of widow of so and so and so and so. This shows that there was difference between the two sets. So here, Your Lordship, therefore, applying this in our case, the father's name of he was exclusively recorded, and the property would devolve on his daughter because, admittedly, undisputably, he was survived only by a daughter.
And the property was found recorded in the name of son of the daughter. Ultimately.
Yes, he was found.
Found in possession.
घर has been mentioned.
मेरे ख्याल से उनके नाती के नाम पर.
नाती के नाम पर घर, उसका क्या और वर्ड है? घर है.
That's all.
That's
आपको क्या? इनका सबमिशन लिखा लेते हैं.
जी.
इनका सबमिशन लिखा लेते हैं. The learned counsel for the appellant has referred to the following judgments. Number 1, Prabha means number 1, essay number 127 of 2014, decided on 24/2/2022. Prabha means versus Maratha Ikka. Martha Ikka and others. In essay number 127 of 2014, B 2003 SEC Online JHAR 432, Dhani Manji versus Ranga Manji. 3 2003 SEC Online JHAR 432. ये तो हुआ धनी मांझी ना. हाँ यही है. दो जजमेंट्स, ठीक है. And also the judgment reported in bracket 1996 5 SEC 125 Madhu Kishwar versus State of Bihar. By referring to the judgment passed in the case of Prabha means Supna, the Learned Council has submitted that the substantial question of law framed in the said case was directly related to inheritance of inheritance by female heirs under customary law, and he submitted that the same case was related to the tribals of Orao caste, but while answering the substantial question of law, this court has taken into consideration the manner in which the custom is required to be established. He has submitted that while answering the question of law, the inheritance under Santals as well as Oraon have been considered, and it has been duly recorded in the said judgment that with respect to Oraons of Chotanagpur, reference was made to the book written by Sri S.C. Roy with respect to Santhal tribes, and
No, that was with respect to Urant.
with respect to Oraon tribes, and so far as the Santhal tribes is concerned, the relevant report is the gangsters report. The Learned Council has submitted that the inconsistency in connection with the right of inheritance, denial of right of inheritance to daughters have been recorded as back as in gangsters report, and even the court has taken into consideration that there is inconsistency with respect to different judgments on the point of inheritance. The Learned Council submits that the test to establish custom was heavy on the plaintiff, who denied inheritance to daughter on the ground of customary law, and the basic ingredients to establish custom in terms of the judgment passed by the Honorable Supreme Court reported in bracket 2013 bracket close 4 SCC 97 has not been established. The Learned Council has also submitted that it has come on record that the parties are Christians by religion, correct?
Yes.
Parties are Christians by religion.
Because it in the plaint itself,
Christian
they have said that they are
the
governed by
just a
Santhal
moment.
Christian.
the Learned Council has submitted that as per the plaint, the parties are governed as Santhal Christians
Are governed by tribal.
and,
Santhal law.
and governed by Santhal law of inheritance in connection with inheritance of women with respect to the properties.
Customary law.
But
Customary law of inheritance.
since in the present case the inheritance by sole daughter is under consideration, it is not relevant to examine as to whether by which religion they were governed. है ना? Yes, Mr. Rao Gupta. It is not necessary to examine.
Because para 1 they say that the plaintiff as well as defendant number first party and pro forma defendant belong to Santhal Christians by caste.
Governed by tribal.
And they are so therefore
So
and
therefore, I just want to observe that the religion will have no relevance because it is a matter of relating. It is a matter relating to inheritance by only one daughter.
yes,
क्योंकि किसी केस में ये इशू आ सकता है, जैसे हिंदुआइज ट्राइब होता है, क्रिश्चियनाइज्ड ट्राइब भी हो सकता है.
That is not the case.
That is not the case here, but
It is an admitted case.
in one or the other case, this issue might crop up.
Yes. Honorable Appeals Court has also said it has to be examined on each and every case.
Yes.
so my basic argument would be that a general custom on the basis of which the females are being debarred from inheritance,
But
that has not been proved.
The Learned Council has submitted that the general custom which was pleaded by the plaintiff debarring inheritance by daughters with respect to in connection with daughters belonging to Santhal tribe having not been proved, the substantial question of law is fit to be answered in favor of that.
And Your Lordship, both the courts, they have primarily relied on Ganjar's report, not the evidences that they have proved the custom. They have
The Learned
primarily-
Council has also submitted that both the courts have primarily referred to Ganster's report, but the reference is selective in nature. The Learned Council has also submitted that the Learned First Appellate Court at one point has confined the case of the appellant only as to whether the husband of the daughter, as to whether the daughter was married in Gharjamai form. The Learned Council has submitted that in the written statement, both the pleas were taken by the appellant. While referring to the judgment passed by this court in the case of Dhani Manji, the Learned Council has submitted that the facts therein were somewhat similar, and in the same case, the trial court as well as the first appellate court had held that the plaintiff had failed to prove the custom of a married daughter being excluded from inheritance. We have submitted that it has been held that the burden was on the plaintiffs to establish that there was custom amongst the tribal in question of excluding a married daughter from inheritance. He submits that in the same case, the concerned tribe was Santhal.
Yes,
Santhal.
same.
Ah.
Here also.
In the present case also, it's the same tribe which is involved. With respect to the judgment passed by Honorable Supreme Court in the case of Madhi Kishore, the Learned Council has submitted that the provision of Section 7 and 8 of Chotanagpur Tenancy Act was directly under challenge, being ultra-vires to the Constitution of India. And a plea was raised to hold that the customary law excluding female from inheritance was violative of the fundamental rights, and such a plea was negated. The Learned Council has further referred to the body of the judgment to submit that it has been clearly observed therein that each case has to be considered on its own fact, and the full facts were not placed before the court, before the Honorable Supreme Court. The Learned Council submits that in order to claim exclusion from applicability of general law, the onus was on the plaintiff to prove such an exclusion, which the plaintiff in the present case has failed to prove, and therefore this appeal be allowed.
Yes. And Gancher's report by itself cannot be taken to be laying down a general binding custom, because it also takes note of.
The learned counsel has submitted that the gangster's report itself revealed that there was inconsistency in with respect to exclusion of daughters from inheritance.
Yes, and therefore that by itself cannot be taken as a gospel
And
truth to.
Gospel truth क्या
No,
उसमें उसी में inconsistency है.
because yes,
The learned counsel submits that this aspect of the matter with respect to gangster's report has not been taken into consideration by the learned courts.
First of all, Manoj, I would like to say that what is the substantial question? Earlier, the substantial question of law which was framed in this case, to that Manoj, his submission is that he is not taking that. He has actually waived off. The only substantial question of law which has to be answered by this court is whether the alleged custom among Santals debarring females from their right of inheritance over the land by the ancestors satisfies the test of binding custom, as has been laid down in the case of Lakshmi Bai Purusa Jinsas. My first submission before your Lakshmi, so far as the Lakshmi Bai case and the Bhimsiya case, your Lakshmi, both these cases on the Hindu succession. My Lord, may kindly see what was decided in this. But in this particular case, your Lordship, the issue before the Honorable Apex Court, your Lordship, that, my Lord, in case of adoption, whether a child outside the family can be taken up.
Let us read the judgment.
Yes. In this appeal has been preferred against the ensuing judgment sentences. The facts and circumstances giving rise to this appeal are: one Narayan Bua Gosavi, a descendant of Sri Sant Eknath Maharaj, was vested with exclusive right to carry the palki and padukas of Sri Sant Eknath Maharaj from Paithan to Padharpur at the time of Astadai Ekadasi. He died in 1951, leaving behind his widow, namely Srimati Lakshmi Bai. Krishna Bua, brother of Narayan Bua, had predeceased him, leaving behind his widow, Srimati Gopika Bai. After death of Narayan Bua, the appellant Srimati Lakshmi Bai was vested with the exclusive right to carry the palki and paduka. The respondent herein, who are also descendants of Sri Sant Eknath Maharaj, served notice dated 6/5/1971 upon Sri Vasant Bhagwat Pandava, stating that he must not leave his son Ravna, aged 8 years, in adoption to Lakshmi Bai. On 10th of May 1971, some of the respondents herein filed civil suit 47 of 1971 against Sri Vasant Bhagwat Pandava, Srimati Lakshmi Bai and Sri Gopika Bai, restraining them from effectuating the adoption of Ravna. A aforementioned suit was withdrawn subsequently in 1974. It was during the pendency of the said suit filed by the respondent on 11/5/1971 Ravna was adopted by Srimati Lakshmi Bai. After performance of all requisite ceremony which was conducted in the presence of huge crowd, where process of giving and taking of child by the parents of Ravna and by Srimati Lakshmi Bai respectively was held. Ceremony was performed by a priest and the several photographs were also taken on this occasion. On the same day, an adoption deed was executed and registered in this respect. The said deed was duly signed by seven witnesses owing to the fact that the respondent had tried to create some hindrance in the performance of duties of the opponent in relation to carrying out the Palki and Paduka, Srimati Lakshmi Bai and Sri Gopika Bai filed title suit against the respondent seeking a degree of perpetual injunction, preventing them from causing any obstruction or interference in the exercise of their exclusive rights. The suit was contested by the respondent and a large number of issues were framed. Trial court decreed the suit, holding that the adoption by Raghunath by Lakshmi Bai was valid. And the ceremony of giving and taking of child and that performance of all other religious ceremonies were conducted. And also that the photographs taken at the time of adoption could be relied upon. The said adopted child Raghunath inherited all the properties of Sri Lakshmi Bai when she died before the trial suit commenced. The inheritance was held to be valid. It was held that there was no custom of adopting child only from within the family, and consequently adoption of Raghunath by Sri Lakshmi Bai from outside was upheld. This was actually the issue. Aggrieved, the respondent preferred civil appeal for certain reliefs. Opponents also filed cross appeals. Various other points were considered by the first appellate court, after which the decree of Supreme Court was reversed by judgment and decree dated such and such, by which it was held that the respondents had proved that there did not exist a custom which prohibited the taking of a male child in adoption from outside. The adoption itself was suspicious and independent witnesses were not examined. The witnesses who proved the validity of adoption were interested, and adoption deed was also suspicious. Feeling aggrieved, the opponent preferred second appeal, which was dismissed by the High Court by issuing judgment concurring the first appeal. Hence this appeal. In this appeal, Your Lordship, Honorable Apex Court considered Section 3A of 1956 of the Hindu Census. It is quoted in para 6. Section 3A of the 1956 defines custom as follows. Expression custom used signify any rule which, having continuously and uniformly observed for a long time and has obtained the force of law among Hindus in the local area, tribe, community, group or family. Provided that the rule is certain and not unreasonable or opposed to public policy, and provided further the case is rule applicable only to family, it has not been discontinued by the family. Thereafter, custom is an established practice variance with the general law. Custom varying general law may be general, local, tribal or family custom. General custom includes custom common to considerable class of person, custom which is applicable to locality, tribe, sex and family called a special custom. Custom is a rule. Thereafter, certain judgments have been considered by Honorable Apex Court. BMCI is also a leading judgment on this point, and it has been taken into notice, which has been taken into notice by the appellate court also in the impugn judgment before. BMCI has said that trial court has said it is not helpful for the opponent. Appellate court has said no, BMCI will apply. So far as BMCI, which is the basic judgment, which has been also taken into consideration in the Lakshmi Bai case, that has been already taken note by the appellate court. And what is custom, how is to be followed, etc.
Where is the consideration of BMCI in the appellate courts?
Yes.
And have you annexed a copy of this judgment, 2006? You have not annexed along with this
Yes.
volume?
Certainly.
ये judgment है क्या? 2006 का 13 SCC 627. हाँ बताइए कहाँ है कंसिडर? बताइए कहाँ है इसका कंसिडरेशन? Yes, please tell us. Yes, please.
Yes. Yes. It is internal page number 13 of the learned trial court discussed and observed that the case of Lucy and others versus Janabi Janababa reported in
Internal page
2007
13, इसकी तो रनिंग पेज ही नहीं है हमारे पास।
इसमें
कौन से इंटरनल पेज में?
मैं जो दिए हैं
आप रिपोर्ट से पढ़ रहे हैं कि इंप्रूव जजमेंट से पढ़ रहे हैं?
अपील कोर्ट का जजमेंट,
अपील कोर्ट का पैरा नंबर बताइए, इसमें नंबरिंग नहीं है।
पैरा नंबर 13। In the background of authority of law Narayan Soren,
Yes.
उसके बाद ये जो second पे third paragraph है, the learned trial court discussed and observed the case of Himsiya and others versus Janabi Janalwa reported in 2007 JCR Supreme Court is not by our apex court has been pleased to observe that the custom is authoritative, it stands in force of law, regulate the conduct of man in most of the important concern, fashion in arbitrary caprice, decide the matter of trifling manners, they are expressions of moral feelings. Customs have no force in simple society, however, the learned trial court has said such authority of law is helpful for the plaintiff and adopting general law for deciding the matter in controversy travelled in wrong directions and failed to consider that Santhal customary law is authoritative and it stands on the force of law for guiding Santhal community. Such background are admitted customs. In such background, the admitted custom of party to this suit certainly takes the place and governing overriding effect.
Admitted custom कहाँ से आया?
जी,
Admitted custom.
admitted custom ये है,
नहीं, what is the admission?
no पता,
Plain and written statement से
वही
admission.
वही हम बता रहे हैं।
Fine.
इसीलिए इसको हम लेट पढ़ना चाहते हैं। First of all, इसमें पारा भगवान देखा।
You see, one thing is not in dispute, that as per ancient custom they were excluded.
No, parties, two things parties have admitted.
What all the two things which they have admitted?
Yes, both the parties are.
Yes, yes. Admission क्या है?
First ये कह रहे हैं कि सब parties are governed by the customary Santhal customary law in matter of inheritance. There he is also not saying so. He not be
Santhal customary
law in matter of inheritance. अच्छा, we have specifically pleaded in para.
just matter of inheritance.
Yes. Para.
Your pleading is that you are governed by Christian Santhal customary.
But he is saying that they are Santhal Christians by caste, and they are governed by Santhal customary law in matter of inheritance. That what is the para?
Okay.
And second para, he is saying that Hindu law nor Muhammadan law is applicable to. Third para is relevant for me. But that according to Santhal Christian customary law of inheritance, an ordinary married Santhal Christian daughter of a Christian Santhal is not at all.
Appellate court का record दीजिए, trial court का दीजिए.
हम प्लेन पढ़ा.
हम भी plain ठीक हो गए. हाँ, para number 3.
Para number 3.
Para 3 of plain.
According to Santhal Christian customary law of inheritance, ordinary married Santhal Christian daughter of a deceased Santhal is not at all entitled to inherit her father's property. In such a case, if a sonless Santhal Christian dies, the property will pass on to his regenants, and his regenants shall be entitled to inherit his movable and immovable property after his death. The plaintiff and the defendant first slaves, as well as for former defendants, are descendants of Ticket Murmu and the deceased who had his Jamabandi lands in village Mangrudi.
ये तो
So-
पैराग्राफ स्पेसिफिक बताए. पैरा 3 यू आर रिलाइंग अपॉन
अभी हाँ,
एडमिशन.
इसके बाद इसमें हम लोग इसमें इनका ये देखा. अच्छा, पारा 8 भी रिलेवेंट है हमारे. पारा 6 और 7 में भी हमने ये प्लीड किया है. She was married in an ordinary form of marriage, because requirement is if normally there no inheritance, but
Para
in the Garjamai form of marriage, then entitled. 7, 6 and 7.
I am referring to para 3 and 7.
And then 8 point what we find that we have specifically said that after the death of Harmamu, the recorded tenant of Jamabandi number 30, the plaintiff being the nearest agents, legally inherited the land of the concerned Jamabandi 30 according to the Santhal customary law of inheritance. So there is a pleading to that.
Para 3, 7 and 8.
Then my lord may see what are their defenses. Para 9, your lordship, is the main defense they are relying upon. The statement in para 3 of the plaint are partially correct. Para 3 I had already said.
Partly.
इसका जवाब भी दे. It is submitted that there is no Santhal Christian customary law. As stated, correct position is that Santhal tribal law of inheritance given in para 46 of Benedict's settlement report also apply to Santhal Christians in the matter of inheritance. So he admitting that yes, parties are governed by the Santhal law of customary.
गैंगस्टर सेटलमेंट रिपोर्ट को रेफर करते हुए.
हाँ, लेकिन वो उसमें भी संथाल की बात है. इस पर ये डिनाई नहीं कर रहे हैं कि आई एम गवर्नड बाय हिंदू लॉ और आई एम गवर्नड बाय.
कोई बोल रहा है कि गैंगस्टर्स रिपोर्ट इज नॉट.
आई एम कमिंग टू दैट.
आगे बढ़िए.
उसमें ये क्या एक्शन में इसको
आगे
बता. From the said para 46, it would also be evident that the law not allowing females to inheritance was changing owing to the force of public opinion during the times of Gabinet's report settlement. And daughters not married in Garjamai. What he is saying, please may kindly take into note.
आप बीच में मत बोलिए ना.
हम बता रहे. Daughters are not married in Garjamai form. Also inherit paternal property. Contrary statements made in para 3 of the plaint are not correct. What is their pleading is that even the daughters who were not married in the Garjamai form, even the ordinary form, which what we are saying, they will also inherit.
That's right. They
That
are
what-
taken
what-
a specific
that-
plea to that effect.
Yes. So basically, the issue before the trial court was that first issue was whether the marriage was in the Garjamai form or the.
That is negated. You forget it. That is not the substantial question of law here.
That is relevant. That is relevant and the sense because this is the case on which they have fought.
No, it can't be like this. Please, what they have fought about is the plain and the written statement that we are looking at. Right? What they have, what the parties joined issues at is the plain and the written statement.
Yes.
that we are
Yes.
looking at. They joined issues on two points,
Right.
and it was alternative, and it was not derogatory to each other. Right?
No.
One was whether she was married in Gharjamai form or not, and second, irrespective of marriage in Gharjamai form, whether she inherited the property.
No, that is not the pleading.
That is the pleading.
That what is the pleading is
That is the pleading.
No. What is the
आप
pleading is
उसमें कुछ
Not-
अपना कुछ शब्द घुसाना
नहीं, हम तो
चाहते
एक वर्ड भी अपना नहीं बोले.
हैं. हम भी
इनका
ये देखिए even during the time of Ganses survey and settlement
yes,
and daughters not married in Gharjamai form also inherit parental property and contrary statement made in paragraph 3 is denied.
वही हम भी कह रहे हैं कि जैसे सिर्फ ये इनका प्लीडिंग इसी पॉइंट पे है कि अगर आप घरजमाई फॉर्म में नहीं भी थे तब भी हम हमारा इनहेरिटेंस हो।
हाँ तो बस
ये बात
joint issues on this.
लेकिन जहाँ तक कि एडमिशन का बात है, एडमिशन का कस्टमरी
So it is not in dispute that there was an ancient custom so far as exclusion of daughters in Santhal inheritance is concerned.
yes,
It is ancient, बहुत दिन से चल रहा था और यही था.
and it has not changed also.
ये
अब now
changed,
the
not
question-
changed, whether it was consistently being followed, whether it was uniformly being followed, whether it was being followed without any exception is the issue which is required to be
Yes,
solved.
yes, that's what I'm saying.
Yes, that is
also
why the reference of the judgment of Lakshmi Bai is there.
that's what I'm saying. So far as the custom velocity is concerned, the
अब
custom
उठेंगे 2:15 हम आज जाएंगे, ठीक है? और आपका वो वाला मैटर 2:30 बजे से 15 मिनट और लगेगा आपको?
नहीं हमको टाइम लगेगा।
कितना टाइम लगेगा?
इसमें हम इसमें कम से कम I will argue for more than 1 hour.
कल सुबह सुनेंगे 10:30 बजे। ठीक। आपका तो हो गया? The learned counsel for the respondent has commenced his argument and he has submitted that so far as the judgment passed in the case of Lakshmi Bai is concerned, the same was primarily relating to the point of adoption amongst the Hindus. He has further submitted that. He has further referred to paragraph 3, 7 and 8 of the plaint and has further made reference to paragraph 9 of the written statement to submit that it stood admitted on the side of the defendants that as per customary law of Santhal, the female was not entitled to inherit the paternal property. Okay?
except in the Harjamai form.
Except when she gets married in Gharjamai form of marriage. He also submits that the defendant specifically asserted in the written statement that the daughter had undergone Gharjamai form of marriage, which they miserably failed. Okay? And no substantial question of law in connection with the point of Gharjamai form of marriage of the daughter has been framed in the present case, and that finding stands continued.
That was framed, but he's waived that
अच्छा,
substantial
कोई बात
question.
नहीं, कोई बात नहीं. Since another part-heard matter is fixed for hearing in the second half, let this matter be posted for further tomorrow at 10:30. सुबह आ जाएंगे प्लीज, 10:30 बजे सुनिए, उसी समय दिखाएंगे. सोचो कि आज हम दिखाएंगे इसको, कल दिखाएंगे. तो एक बंडल ये सब
So कल 1 मिनट के लिए हम उसको डेजिग्नेशन
हाँ पेज में
एक मिनट के लिए वो जो दिए थे ना,